Sloppiness, sloppiness, sloppiness. That's the word federal judges are now using again and again when describing the conduct of the Trump DOJ. And this wave of resignations and internal chaos inside the Department of Justice is seriously damaging its ability to function. Basic facts are being mishandled, people are being detained, yet key details about them are flat out wrong. At the same time, many detainees are being denied access to their belongings, their lawyers, and their constitutional
We are
protections.
seeing lawful resident or other filing habeas corpus detention, arguing their detention is illegal. In multiple cases, the dog does not even have attorney properly responding after people are locked up, deadline are missed. Petition go answered. Judge are left saying there no opposition here, so we have no choice but to others and release. Think about that. I say borders patrols detains someone place them in facilities, and then the dogs fails to file motion defending the detention. One the person find concerns and challenges it. In other situation, the government president incorrect background information. One judge pointed out that the person, the dog criminal committed misconduct in 209 was 4 year old at the time. Judge are not pushing this off. The warning that this repeated careless signal deepens procedural and failure. In West Virginia, Judge Burgers sharply criticized the government action. The Trump administration claimed a man detained by ICE had a 209 marijuana possession conviction, but the court noted the man was 4 year old in 209. The document I see relied or belonged to someone with the same names but different birth date, birthplace, current name, and immigration state. Judge Burgess wrote that the kind of slowness reinforced serious concern about how the government is depriving properly peoples of liberty. In another case, judge trusted held the administration in a civil contempt after an ICE detainee was transferred to Texas in violation of the court orders and is depriving people of liberty and to Texas violation of a court order and then released in El Paso without his belongings. The judge orders reimbursement of the $568 the man had to spend on a flight home. In a separate incident, after a judge orders release from IC custody, agent repeatedly and kept the individual car's keys challenges person the detention, and the dog response that it is no opposition to the argument. Judge then ordered release because the government offers no defense. One federal judge started plainly that the respondent had not filled any opposition at all. These are minor procedural mistakes. These are people lives. Meanwhile, thousands of dogs, employees, and lawyers have department mind internals. Upheavals. Attorney General Pam Bondi recently appeared on Fox News and focused her comment on broader themes about safety and the economy rather that addressing these courtroom issues. Critics argue that serious concern about detention practice research direct answer. Legal analytics Harry Lightman of the Talking Feed broadcast say the patterns geo beyond simple careless. When the same errors happen repeatedly, missing documents, ignored deadline, incorrect record, it struggles suggested systemic breakdowns quote across multiple districts have no repeated violation of orders. And Litmans also pointed to distributing the report about condition extended confinement beyond normal holding periods, inadequate faculties, constant loitering, and lack of basic necessities in its similar condition exist in a state prison. Constitutional challenge would quickly flow. There is also concern about staffing shortage with experienced attorney leaving less prepared lawyers are being assigned to defend complex detention case. Some dogs attorney have faced the contempt finding after being are able to obtain accurate information from ICE in time. This ruling can permanently affect legal careers and observers guessed this may be mix of administrative overloads, influence, coordination, and a modern enforcement cultures that prioritize detention first and legal process later. In some cases, government lawyers have acknowledged mistake in court, something rarely heard before. The core issue remains this federal court have repeatedly emphasized the individual detained in the United States have the right to challenge the detention habits corpus is not optional when the government fails to properly justify confinement. Judge well order release what we are witness is a dogs under strain. I say enforcement action under intensive judge scrutiny and court increasingly unwilling to tolerate procedural failure. The domino effect inside the Department of Justice is no playing out publicly in a courtroom across the country. There are much more to examine as this case continue unfolding.